Okay, welcome back to continuation of. Right, welcome back to discussion of terms of contract. So we would like to discuss categorization of terms, what we call the relative importance of terms of contracts. So by categorization of terms or relative importance of terms of contracts, we want to explore whether terms are of the same status, whether terms are of equal importance. And of course, this reminds me of George Orwell's Animal Farm. George Orwell's Animal Farm, all animals are what? Equal. But some animals are more equal than others. And I'm actually scandalized that a lot of you appeared surprised, and because they haven't even heard about Animal Farm. In all honesty, if you've not heard about Animal Farm, raise up your hand. You see, you are saying, good, you're my friend. I was definitely, yes, if you haven't heard about Animal Farm, raise up your hand. I have only one friend who is very honest. Okay, so since all of you are insisting that you know, Precious, Delali, Abu, Sajid, Precious. Okay, Precious, as soon as we finish this class, you come and tell me about Animal Farm. But now let's continue with relative importance of terms of contracts. So as I was telling you, the purpose of this segment of terms is to find out whether terms of contract are of equal importance or some are more important than what? Than others. So that is what we want to discuss. And it is imperative to note at the outset that traditionally, terms were classified or categorized into two compartments with respect to their relative importance. What were they? Terms were categorized as either a condition or a warranty, as either a condition or a warranty. And this was the situation for a very long time until the last half century when we got a hybrid term, a term which lies between condition and warranty, what we call innominate term or intermediate word term. So we will take them one after the other and quickly dismiss them. So condition. Conditions are statements of facts or promises which form the essential terms of the contracts. They are of paramount importance in the sense that they go to the very root of the contract. And that has got certain implications. Because they are of paramount importance and they go to the very root of the contract. In the event of a breach, it entitles the innocent party to certain remedies. First and foremost, a breach of a condition will render the contract repudiated or terminated. The contract will be discharged. When we say that the contract is discharged, that is to say that the contract will come to what? An end. The contract will be repudiated. And the innocent party will no longer have to perform any obligation. And not only that, it will also entitle the innocent party to sue for damages for breach of contract. So breach of a term of contract classified as a condition will result in discharge by termination or termination of the contract, it will let the contract come to an end, that it will be repudiated. And when it is repudiated or when it is terminated, then the innocent party can also sue for damages for breach of what? Contracts. And there's a very old case, very old case, an interesting one. Let me find. Well, in Possard and Spears, a very old case, a singer failed to take up a role in opera until a week after the season has started. You remember opera, the concerts, you know, in those aspects of societal life. So we have a situation where a singer has been contracted to take part in performances in the theater. And it was required that she will be available to perform for the entire period. So the singer was late by 1 week. And the organizer or the person who hired the singer to come and perform wanted to terminate the contract, thinking that failure to arrive until 1 week later was a term of major importance going to the roots of the contracts. And you come and bring away. Make sure where is that? This is Vanessa. Make sure that the sign, right, and you bring everything to me. We continue another time. Yes, this was the other one.